Hi, my name is Maria Tojan. I'm a lawyer based in Sydney. I was admitted in the Supreme Court of New South Wales and the High Court of Australia. I'm the founder of Tojan Brill Lawyers, a fully compliant, client-serving legal practice that I built from the ground up. My firm, Tojan Brill Lawyers, has been serving the community with good standing for 12 years. And even though the Law Society has unlawfully blocked mine and my partner's, Artem Brill's, practicing certificate, that truth does not change. Because of what has happened to me and Artem, I'm now the founder of a Tojan Brill Justice Project. You may have seen my previous video on the 17th of May. In it, I showed what was really happening and what has already happened to me and my partner. There was interference with our practice certificate, our solicitor data disappearing. We were no longer visible and searchable on the Law Society Registry of Solicitors. And there was non-existence of our paid solicitor membership with the Law Society. But that video also showed something deeper. I showed the extent of the people and institutions I've reported over the years to the Office Legal Service Commissioner and the Professional Standards Department in the Law Society of New South Wales. And those reports and notices were made since 2016. I show the photo of the actual people that I made complaints in my report. And I show the picture of the evidence of my report, just the front page of 102 pages. And there was an exhibits of about 650 plus annexes. So you could see the names and evidence for yourself. And it became clear there is an institutionalized interest in targeting us, because what we expose goes to the heart of legal corruption in this state, in New South Wales. And if you haven't watched the video yet, I encourage you to do so, because what I'm about to share is what happened since then. I just want to put it out there that that video on the 17th of May was my raw reaction to the status of my portal. I mean, could you imagine? You've been practicing for 15 years with unblemished record, your partner as well, unblemished record, have a good standing with the community, with your legal practice, providing services for 12 years. And just like that, your portal shows you that your data, your evidence of being a solicitor is erased. It's not visible. You're not searchable. As if I'm a ghost, that I never existed. Everything that I worked hard for, I put myself through law school, I put my partner through law school, and all that requirements to become a principal, just gone, disappeared, as if I never existed in the first place. And you know, I'm not being dramatic here. It's a situation like existential circumstances. This situation is breaking your reality. I'm a lawyer, and such gross, unlawful acts are being done to me by the very regulator who is supposed to uphold the law, act with honesty and integrity to preserve the integrity of the legal system and the profession. And they're the one circumventing the law, doing unlawful acts. And then I share it with you all. And some of you are just stunned. They're just saying it's awful. How could this be? Is there an error? And I can see it's breaking some people's reality, including other legal practitioners. But yes, this has happened to us. And the Law Society of New South Wales Professional Standards Department and the Law Council, who's fully aware of the lawful process like the back of their hand. They're constantly bringing legal practitioners to NCAT proceedings. They know exactly what they've done. And they were given notice. We gave them notice that they're engaging in unlawful conduct. And the more notice we gave them, the more acts they did to us that's unlawful. And you saw that on 17th of May video. So before I continue, I want to say thank you to those who have reached out to me. Many of you were shocked, and rightfully so, because this challenged your belief how justice should operate. You saw there was no hearing, no procedural fairness, no tribunal. You felt that there's injustice here, and you're right. You feel that injustice. You're asking me questions. How could this be? So 12 days after the video was posted, the Law Society issued a Section 45 certificate against me and Artem, and they declared us unfit to practice law. That was done pretty much by ambush. No hearing, no notice, no charges, no tribunal. And as lawyers, we know that that could never be the process. But that's what the legal regulator has done. The Law Society of New South Wales, the Professional Standards Department, and the Law Council has done. And this was signed off by Miss Valerie Griswold, the very person on the first prompt notice that we gave that she had engaged in unlawful, corrupt conduct. We even gave her notice to recuse herself on the matter, and that she had fabricated findings of misconduct and prior misconduct, which she stated not as an allegation, but as a statement of fact that it exists. She even tried to get admissions from us that there was misconduct, and also gave us an option to withdraw our renewal application, which means to effectively cease being practicing lawyers. So, very first notice, as soon as we received their correspondences in July 2024, we already gave them notice that you're doing unlawful, corrupt conduct. What's even more disturbing is that they used their office to sit there, watch the YouTube video, my 10-minute long video. They screenshotted my YouTube video and they transcribed it. And then without any notice or ever putting it to me, they just attached it to their decision with a public notice. That's an online post on my firm's website. And that was also not put to me. So all these things that was attached to the decision on the 30th of May was something that I just found out when they made that decision that I'm not fit. So they made sure that they deprived me any opportunity to defend myself and to answer. And this also applied to Artem. So this was very targeted. And as I said in my previous video, they just justify that it's a targeted discriminatory act. And it doesn't matter what we do, what evidence we put to them, what law, and we shouldn't be telling them the law because they know it like the back of their hand. They are making annual reports to the Parliament about the disciplinary proceedings, and they're fully aware of the Uniform Law, Chapter 5, even though their decision actually stated that there's no disciplinary proceedings or findings against us. That means there's no legal case against us. And what would be logic is that the only option under the Uniform Law, if you look at their flowchart, which I will put up, is that they can only close the case. But of course, they couldn't do that with us because they have an agenda. They needed to take us out of the legal profession. This wasn't just a personal attack. It shut down a fully operational, compliant law firm of Trojan Brill lawyers. Our clients, in an instance, was left with no representation. There was no warning. There was no transition. Just an email attaching a Section 45 certificate that effectively stated you cannot engage in legal practice. And the Law Society knew exactly what that meant. They knew I was a principal. They knew we have active clients. They knew the consequences and how detrimental and harmful it is. They wanted to cause ultimate damage and harm. The harm is not just to us as legal practitioners, but it also extended to my law firm, forced to cease operation. And that damage also affected my clients. And just like that, in an instance, no longer represented. And on what basis? No legal basis whatsoever. Yes, you are witnessing something tyrannical. This is more than just abuse of power. This is a personal vendetta. Our Law Society New South Wales have been compromised. The very people who are entrusted as officers to uphold the law and the lawful process under the Uniform Law and all applicable laws are using their positions to circumvent the very law they are supposed to adhere to and uphold. They're using it for their own self-preservation. And I'll tell you why. Because I said in my previous video, there is an interest. And the devil's always in the details. Now let me be very clear. What the Law Society of New South Wales has done to us is not just improper. It was and is unlawful. They bypassed the entire disciplinary framework under Chapter 5 of the Uniform Law. They did not take us to NCAT, the tribunal. They made untested allegations, and instead of proving them in the tribunal to be determined independently under our disciplinary proceedings, they issued a Section 45 just like that in their own private meeting, without us being present, without us being heard. We have no idea what they spoke about. We were never given any opportunity to defend ourselves and be heard. Now, under the law, allegations of professional misconduct must be brought before a tribunal to determine, and that's under Section 300 of the Uniform Law. And the other type of conduct is unsatisfactory professional conduct, the less serious type. Professional misconduct is a very serious allegation that needs to be determined before the tribunal. Now, I want to show you that there's this double standard, because throughout the correspondences, and I had very few, so they had my case, myself and Artem, for about almost a year, 10 months. And in that 10 months, they only communicated by correspondence 3 times. And they were not substantial correspondence. They didn't provide any particulars of their allegations despite our repeated requests. They just ignored us. So throughout their correspondences, the Law Society has never referred to the relevant provisions under the Uniform Law and did not even refer to NCAT tribunal process at all. The only thing that they have provided us was some case law, which they themselves have taken the solicitor to NCAT. And that's where I'm going to show you this double standard. Now, there was a case of Tansalat, and I'll provide that reference. And it's a solicitor who actually failed to disclose in their renewal application that there were findings against them. Effectively, their migration agent license was revoked. And so there was a fine against her. And she didn't disclose this in her renewal application. So they took her to NCAT. Now, Tansalat was given the opportunity to defend herself, to be heard, matters presented, evidence presented, and NCAT made its determination. She was able to appeal, she was reprimanded, and she was still allowed to continue practicing, even though there was findings of misconduct against her. She wasn't rendered unfit, but she was given all the opportunity available to her under the Uniform Law. But in our case, as you can already compare, is that there's no findings of misconduct against us, no prior findings of misconduct, nothing. We have impeccable, unblemished record. But we were not afforded any tribunal, no hearing, nothing. They made and fabricated allegations of prior misconduct and misconduct findings, which they cannot substantiate and refuse to substantiate despite all our notices to them to provide particulars, to put their case clearly to us, to provide documentations and their jurisdiction to determine such matters. They always represented that they'll make determination of our fitness in private meetings. So they know exactly what they were doing. So what you're actually witnessing is lawlessness. And it was done quiet ambush behind closed doors. Now, this goes deeper because my firm represents victims of Credit Corp. And I myself am a victim. Through my case, I was able to uncover the unlawful practices of Credit Corp and its lawyers, Piper Alderman and Certis Partners, which I believe has been going on for about 3 decades and possibly even more. What is a pattern conduct is that they plead contracts they don't have in possession or don't exist, and they never actually have to prove such contract. And the thing here is that a contract is not a cause of action. Any lawyer or a law student would know that the cause of action is always a breach of contract. And so if you can obtain any cases of Credit Corp, you can search it for yourself. You will see that the issue of the contract and determining the cause of action of a breach under contract, you will not find it. If anything, that is completely circumvented. And they will be raising things like assignment and so forth, other documents as issues. And the thing is, with legal assignment, you have to assign a legal instrument, a document, a contract. So what's happening is that we're in their way. We most likely cost them a lot of money. And we've disrupted their modus operandi, circumventing the credit laws, where there is multi-million-dollar penalties. In my case alone, Mr. Florent Ammer, in his sworn affidavit, even stated that any breaches of the ASIC Act, one typical breach, will possibly have a maximum of 3.6 million. Now, those matters were not ventilated, they were not tested. So he just completely avoided such determination because it was never ventilated in court. I'm going to show you a diagram that shows what the Law Society should have done in accordance with the Uniform Law versus what the Law Society actually done in our cases. And you'll see that they have completely circumvented the lawful process under the Uniform Law. Now, next I'm going to show you a high-level disclosure diagram which captures the scale of my reporting efforts and the notices I've given that spans about decades. I made complaints and reports to the Office Legal Service Commissioner and the Law Society Professional Standards Department, and I did it to protect the public and to uphold the integrity of the legal system and the profession. But what they did to my reports, it was pretty much concealed. No investigations, no question asked. And I did this not for myself, but because I'm an officer of the court, and I had to report what I witnessed. What I saw was perversion of the course of justice, judges assisting the misconduct, the unlawful practices continuing unchecked in the courtrooms. It's a very urgent and serious situation, and I could not turn a blind eye. I have a duty. I have to report it. There are regulatory bodies designed to take these reports, and they have a duty And if there is possible suspected offences, they must refer it under Section 465 of the Uniform Law to authorities, including police. What you've just witnessed is a state of lawlessness. And yes, this is happening in our legal sector. Help us bring light to this pressing issue. Like, share, comment, and I'll be posting more videos. For more information, visit our website at trojanbrewerlawyers.com.au. Read our call for action to Premier Mins, New South Wales Premier. Sign our petition, and if you want to donate, we have also set up a GoFundMe for those who want to donate and support our cause. Help us protect the rule of law and the public.